listening to Driving Law, a podcast by Kyla Lee about all things related to the rules of the road.
Hello and welcome to another episode of Driving Law. I'm Kyla Lee at Acumen Law, and with me, my co-host, Paul Doroshenko.
Good to see you, Kyla. Haven't seen you all week.
Yeah. Don't bring it up when I'm overworked and you've been on vacation all week.
Well,
And the one day I got something that resolved that I was gonna have a little time to myself, what happened?
what happened?
What happened, Paul? What did I do instead of going for a nice lunch?
I don't remember.
I did your hearing for you.
Oh, yeah, because my phone didn't work.
Yeah.
Yes.
Yeah, conveniently, your phone didn't work as soon as you found out I had made a deal on my trial.
No, although I knew you'd suspect that. Wanted to do that hearing. It was one I was looking forward to.
I mean, I won it about 5 minutes after the hearing, so.
Yeah, I figured that. I thought that would be a feather in your cap one. I wanted to do it for those reasons too. I want to know who the adjudicator is. I'll have to log into the system and see who it was who rendered the decision. Yeah, anyway, I'm sorry that your week has been that busy. As you know, my week has not been anything very pleasant. So, in fact, I'm leaving my vacation today. I've been spending the day cleaning because I have been driven out by mosquitoes. I've lost the battle to mosquitoes inside the building. They're just
Honestly,
getting in the building.
mosquitoes sound better than my life right now. Like I would trade you in a heartbeat.
I'm going insane too. I'm just like, can't wait to get on the road here. So it's record the podcast and start driving back the long drive home.
Okay, so Saskatchewan. What's
Saskatchewan.
up, Saskatchewan? Getting an IRP scheme. So,
Yeah, they haven't. They say they haven't drafted the legislation yet, and they say that this is just for discussion, but they are going to do it. But they want to have discussion first. But usually, when they mention it, it's already a fait accompli.
yeah. Well,
They
we haven't drafted the final version yet, but we've got, the 17th draft, and the 18th will be the one that gets tabled.
Well, as soon as they can introduce it is when the House sits again in September.
Yeah.
So
So yeah, basically they're going to go to an immediate license suspension, immediate vehicle impoundment, immediate requirement for ignition interlock. I don't know how you can require an ignition interlock on somebody who doesn't have a license, but I guess it's a condition on the license. But that's what they're saying. Immediate impaired education courses, immediate safe driver recognition penalties, including demerit points.
yes,
And
there's a couple of important things here.
uh, hold on. Hold on one sec. Oh, never mind. They hung up. That number's called me twice today. I'm sure it's just spam, but you never know. They also say that the impaired drivers would also face new immediate financial penalties. And then on the Saskatchewan government website,
Fines. Yeah.
they say first offense, $1,000 fine plus a 30% victim surcharge. Second and subsequent offenses, $2,000 fine plus a 30% victim fine surcharge.
30-day driving prohibition, 30-day vehicle impound.
Yes, but the thing that's got me looking at this going, ooh, you're about to step into it, Saskatchewan, is that characterization of offense.
Yeah. I think it's intentional. I think they know that.
Why? Why do you explain?
Well, here's the thing. We learned years ago that all of these people at all these DMVs across the country get together at conferences. And BC was the experimental one. That was the one where we were going to make the attempt to legislate in this realm of criminal law
Okay.
to end up with something or basically duplicating criminal law, but calling it administrative.
Right.
And BC was going to be the one that led the way, right? Now, we of course characterized it in this particular way of being not a penalty or not a fine, but a monetary penalty, and not an offense, but an administrative thing. And that was part of the way that, yes, you're right. And I could see the look on your face. Part of the way that we managed to get around that um, concern about the division of powers. So, just to back up a little bit, the federal government has the power to legislate in the realm of criminal law. The provincial government has the power to legislate in the realm of governing roads and highways. And creating an offense would be a criminal code offense if it's duplicating the criminal offense. And so it would be outside of the pith and substance of what the provincial government could do. And the way that they were able to skip around it was a couple of things. They said, first of all, we've been trying forever to deal with impaired drivers and we've never been successful. A. B.
Impaired driving bad.
Impaired driving bad. And this, or after years of mediocre efforts to deal with it, we failed, and so we need other tools.
We've half-assed it for so long. God forbid we try to whole-ass it.
And then this is not criminal, and it's not even an offense. It's not a something with true punitive consequences. We're just being very reasonable with people. We're trying to rehabilitate them.
Yeah.
And besides, if it is going to be like if a person does it more than once, we're going to charge them with a criminal offense. They said that. Never would a person get a second IRP in their lifetime. That would be it.
Definitely not a third, fourth, or a fifth.
Of course, lots of people have had many. And Saskatchewan is talking about your second, your third, your fourth. So Kyla's concern is the way that they've framed it is that it is going to then be, no longer passing this test for what is within the realm of the provincial power. I think they've decided, hell with it. We're just going to now take it to the next step and say, look, BC's done it and everyone's done so well with it. Now, I think their decision to make it a 30-day vehicle or 30-day driving prohibition instead of something longer like we have in BC is to try and get around any challenges of it. And I think probably right in BC, a lot of people who get IRPs fight their IRPs.
Yes.
Do it because a bloody 90-day driving prohibition on top of all those other horrible consequences.
Sucks.
Saskatchewan, they can make it more expensive, maybe more expensive if you fight it, and it's only 30 days, so maybe that will be enough that it hits you. Like they're talking a $2,000 fine instead of the $500 that we have, the monetary penalty we have in BC.
Which is wild. $2,000 is insane.
That's a huge amount of money. It's a huge amount of money if it's going to be based on an ASD. Like, again, if it's based on an ASD. My concern is roadside breath testers should not be used for punishment. I just like they were never intended for that. They were always intended as screeners, and there's good reasons that they should not be used for punishment because they're just not reliable enough to punish people when you don't even have a numeric reading. If you got a numeric reading on the device, the person had to blew twice with 15 minutes in between, and the samples were within 20 milligrams of each other, I'd say go ahead, give them a 90-day driving prohibition. Maybe. I'd have other issues. But
I don't believe, I'm going to take us off topic briefly to say, I don't believe the whole line that the experts always spout that, well, it's improbable that you would have two samples that both agree within 20 milligrams percent of one another, recognizing that they're truncated, and there be mouth alcohol involved.
yeah,
If there's mouth alcohol on one and mouth alcohol on the other, it could have the same elevating impact. You burp up the same concentration of alcohol because you have a consistent burp volume.
You blew as an experiment two samples within 20 milligrams, both with mouth alcohol, no underlying alcohol, on the most advanced
both on the mouth alcohol proof device.
Breath testing device in the world, the Datamaster DMT.
Yeah.
I saw it. I stood right beside you and watched you do it.
It can't be affected by mouth alcohol, and it took me one try with that device to blow mouth alcohol past it.
Well, I tried and I didn't. It rejected my sample, but when you blew a mouth alcohol sample twice. So, but that is taking us off topic. Yeah, I think Saskatchewan. I mean, again, these are things. They're all in cahoots. all of these motor vehicle branches
Sure.
are in cahoots, and they get together, they talk to each other, they've come up with this scheme, and they ultimately want to have an IRP scheme across the country, and it's a good way of extracting money from people. It's back when Colin Hanson presented it to the cabinet, and several people who were cabinet members in the BC Liberals at the time have told me this. Well, several too, but in any event, it was presented as impaired driving cases are costing us $5,000 each to prosecute. We want to turn them into a money maker. What's
Five
that?
thousand bucks. $5,000. That's it.
Yeah, that was about it. A day of court was about $5,000.
That's
A
seems like a
judge, a
bargain.
prosecutor, a police officer, sometimes two police officers. It was
I bet a
costing
lot of
them
accuseds were
$5,000 each.
paying a lot more than $5,000 at the time for their defense.
No, yeah, well, that was the other thing. Even if you made a deal, you're typically paying 5 to 15 back then for somebody who was competent to defend your case. And the other thing was we were winning. We were winning. I was winning. So a lot of us were succeeding. And so they didn't like that either. They wanted a system where people lose, innocent or guilty, didn't matter. People lose and they pay money. And that is how we ended up with the immediate roadside prohibition scheme in British Columbia and how it ended up in Alberta, Ontario, and coming soon to Saskatchewan near you.
There you go. Well, yeah. I mean, I think if they continue to call it an offense, they're going to have a problem because it's going to be found unconstitutional on the basis of it being a division of powers
Have you
problem.
written about this yet? I notice you write an article every day now on Substack. There's something published. 2 articles a day?
One on Substack, one on Medium. Almost every day. I didn't write one on what day was it that I had my trial that I made a deal? Tuesday? Because I ended up with a migraine. Probably because I had to have an extra hearing added to my
Little secret, folks. There's really good dictation software out there now, and you can dictate stuff pretty quick. And Kyla dictates as she drives, as she walks through the office, as she so
sits
and
alone at home and
do
cries.
that at home. But you write good stuff, and so you're paying attention.
Yeah. Well, anyway, yes, that's
Google alerts
my
for these
theory.
things.
My theory is if they keep up this offense language, and especially if they put it in the legislation, that it has demerit points, that it
Yeah.
has a victim fine surcharge, and that the penalties escalate based on offenses, they will have it struck down for violating the division of powers doctrine.
Somebody has to challenge it. Somebody has to
Somebody
challenge it.
will. Somebody will. There's enterprising lawyers in Saskatchewan. Do you not know Brian Pfefferly and Mark Brayford?
Yes, I do
Do
know
you
them. But
think
that's
they
not
will
the
let that stand? I
I
have
don't know.
faith.
I mean, you challenge it and you lose. Like
You know, I love those guys. I think they're
I
amazing.
know, but you challenge it and you can lose, and you're not going to get to the Supreme Court of Canada. The Saskatchewan Court of Appeal might look at it. They're a good Court of Appeal. The Saskatchewan Court of Appeal might look at it and say, this is too far away from what the court accepted in Goodwin. They might. They might. They might also say, you know what, this has been very effective, and they'll pull out some fake stats because the stats are all
Oh
fake.
yeah.
The
Yeah.
stats are all fake.
Look at all the lives saved. Let's
Yeah.
ignore the modern vehicles that avoid accidents automatically. Let's
Yeah.
ignore the fact that the population generally consumes less alcohol now and the stigma around impaired driving has increased significantly. Let's ignore the massive effect that the pandemic had on human behavior.
Uber and Lyft.
Yeah.
Like,
The
and
availability.
drunk driving deaths are so down. Uber and
Yeah.
took
And
away a bunch of legal rights, and now it's become entrenched that where charter rights are just getting eroded faster than ever before. But
the
wants
coroner
to point
also
out
stopped
Uber and
investigating.
Lyft.
Coroners stopped investigating obvious death cases.
Yeah.
Oh, it shows with thumbs up there. And what was the other one? Oh, aging population.
Yes.
So, and younger people aren't becoming licensed,
Hard driving. Yeah.
as you know,
Yep.
with a child who's not, I will never understand, but yeah.
Everybody makes their own decisions, but this seems to be a common thing
For me, getting my license was like the first thing I needed to do when
to escape.
yeah,
Yeah,
get,
but you live nowhere where you could take a bus.
that's true. I did live nowhere. Nowhere is in
I
fact.
had to get a license because I had to escape, but I also had to work. And then soon after that, my car was my place to live. So
No.
it's how it goes in life.
That is how it goes. Okay, so moving on. Other things that we should talk about. Ontario. Man, you talk about the Saskatchewan Court of Appeal. They're all up to good work. The Ontario Court of Appeal, however.
Strange, huh?
So this case came out today called Circusoon. Now, Circusoon is an impaired causing death. Uh, Weirdly, Ontario seems to be the only place in Canada actually prosecuting like per se cannabis impairment.
Hmm.
So this was a crash. Marijuana and paraphernalia were found in Mr. Circusoon's car. He admitted to police he'd had cannabis the day before. They took him to the hospital. The hospital took blood samples. And the 4 hours after the crash, the blood samples showed an average THC concentration of 5.2 nanograms per milliliter. Of course, the legal limit being 5, so slightly over the indictable limit. At trial, he's acquitted. And the court actually gives a directed verdict of acquittal, saying that the evidence on impairment was so weak a jury couldn't possibly convict. That the statutory presumption that exists in the criminal code for blood drug concentrations doesn't apply to blood samples seized by way of search warrant, as opposed to blood samples seized by way of blood demand.
Good point.
And
Interesting point. Yeah, sure.
yeah,
Sense.
I wrestled with this in that trial I ran forever in Surrey. You know the one I'm talking about.
Mhm.
I wrestled with that because that was also a warrant case, and I was like, I don't know. The code actually says that it has to be by a demand anymore for the presumption to be engaged. And it never came up.
Yeah.
So we never had to get into it, thankfully.
Yeah.
Well, not thankfully, because it didn't, it didn't matter. Let's just put it that way. Um, but yeah, so the judge basically said, there's no shortcut. And so, given that there's measurement uncertainty in the lab results, there was reasonable doubt. I don't know that measurement uncertainty in any event wouldn't be relevant on presumptions, but I put that aside. And then Mr. Circuson was also acquitted of dangerous driving because the other driver was like distracted when entering an intersection to make a left, and Mr. Circusoon had sped through the intersection straight and hit the left turning vehicle, very much like Chung from the Supreme Court of Canada. So
Yeah.
I can understand the dangerous driving reversal because the facts really did mimic those in Chung. But where I don't like it is the legal shortcut conclusion. So the Court of Appeal concludes that the blood drug concentration evidence was erroneously not subjected to the presumption. That the statutory presumption in the criminal code does apply to blood samples regardless of whether there was a warrant used to obtain them. And that's because of the language of the criminal code. Parliament changed the language, taking out the requirement that it's pursuant to a demand to try and simplify the cases, or as we know, get more convictions. And
Take,
so,
take away some procedural steps that
yeah.
created fairness.
Yeah. So basically that's what the court comes to the conclusion on is yeah, nope, the way the code is written now, it does require that the presumption apply so long as there's a blood sample, which is wild to me. Like that's bonkers.
I just am, well, you and I have the same complaint about presumptions. So
Well, I mean, but presumptions, even like legally, are unconstitutional if they result in an accused person being convicted, even where the trier of fact has a reasonable doubt. And the measurement uncertainty is proof here in this case. There was plus or minus 0.4 nanograms per milliliter measurement uncertainty, so it could have been as low as 4.8, which would have been below the per se limit, at least on the indictable offense. And so how can you say that the presumptions can apply there on those facts?
yeah, I it just feels to me every time that it's the court's not understanding
Yeah.
not understanding the room for doubt.
Yep. So the court says at paragraph 39, this new blood drug concentration offense is different in structure than the previous over 80 provision as appeared prior to the 2018 amendments. The previous over 80 offense criminalized operating a motor vehicle and other conveyances with BAC exceeding milligrams of 100 milliliters of blood. It is now an offense to have a certain BAC or BDC within 2 hours after having operated a conveyance. This makes it unnecessary to prove the BAC at the time of driving. Second, Parliament enacted the presumptions to facilitate proving this, blah, blah, blah. The statutory presumption relevant to this appeal is 320.31 sub 2, which provides the result of an analysis made by an analyst is proof of a person's BDC at the time the sample was taken in the absence of evidence that the analysis was conducted improperly. And so the court reads it so narrowly, like unconstitutionally narrowly.
Yeah.
Like it's wild. Oh, I'm sorry. Actually, mathematically, we can't say that he was over 5.0 nanograms per milliliter. But because there's no evidence that the analysis was done incorrectly, which, by the way, you actually can't get evidence of because they wrote provisions that prevent you from getting that evidence. Too bad, so sad. Could be innocent.
Yeah.
But it's simpler. It's simpler to convict now. And that's what Parliament wanted.
As we've said before, it's no longer an issue of what your blood alcohol concentration is. It's a issue of what the blood alcohol concentration says. It's not an issue of whether or not you're guilty or you're impaired. It's an issue of we have made it this level. And I don't think there will be people will be up in arms protesting it. I think this is just the state of things now, and it's unfortunate. As I've said before in the past, when I borrow something, I like to return it in better condition than when I borrowed it, or at least is in good condition. And I borrowed the justice system during the course of my 27 years of doing this, and I'm returning it in condition that is not as good as it was when we got it.
Not your fault, though.
Nope.
Jody Wilson-Raybould's fault.
It was, yeah. Well, first it was Harper who got rid of evidence to the contrary, and then it was Jody Wilson-Raybould who made all of these changes.
I could live under the 2008 amendments. Those were fine.
Evidence to the contrary was useful. It was a way of protecting it. Sure, it shifted the onus to the individual, but it protected people from being wrongly convicted. Simple. Like
I came up post 2008 amendments, so
fine for you. Yeah.
Oh. And again, I don't know, maybe the future impaired driving lawyers of our country are going to be just fine with the Part 8.1 provisions.
Smart enough to figure out ways to ensure that innocent people aren't convicted.
How? The provisions are written in such a way that convicts the innocent.
I know, that's the point. That's why I say you think the future lawyers are going to be smart enough to find a way. I don't think they will. I think it's sort of done at this point. Yeah. And I view that as the direction of our courts generally. I think we've moved from, rather than taking the lessons from seeing all the people who were exonerated as a result of DNA, rather than taking the lesson and saying to ourselves, well, if that many people are being exonerated in circumstances where there's DNA, how many people are being convicted in cases where no DNA was obtained? How often is our proof beyond a reasonable doubt standard wrong? And it's often enough. And yet nobody ever extrapolated beyond that. They'd never thought to think, oh, okay, if we've got 10% of people with DNA cases are actually innocent, or even 3%, then what about the rest of the cases where there isn't DNA? Impaired driving cases, are 3% of those people innocent and were convicted, or 5%, or what have you? But nobody's taking it that step. It, as you know, breaks my heart.
Yep. Nobody's there to advocate for the lowly drunk driver.
Well, I mean, we do, but it's just nobody, we're not pushing any doors open anymore that way. We're succeeding for our clients' cases, but are we really shaking things up the way we used to? This is a discussion Kyla and I have from time to time. 10 years ago, we sure as heck were.
Went to the Supreme Court of Canada for Wicked as an intervener.
Well, we'll see whether or not we get anywhere with that. You changed the law so many times. Think how many amendments in the Motor Vehicle Act are the Kyla Lee amendments. We don't see anybody doing anything like that. And then it was only you and me,
It's made me really depressed that like my legacy in this world might be a shittier motor vehicle act.
Yeah. Well, it is shittier. Yeah. I mean, it's tighter in some respects, but it didn't improve the opportunity to exonerate yourself. It didn't make it easier to show that you're innocent. That's for sure. Oops. Well, it's my
Uh,
leg too.
well, on that depressing note, let's lighten the mood and
Sure.
talk about the ridiculous driver of the week. This one I feel like almost lends itself to a country song.
Yeah, it does actually. If you'd mentioned that to me at the beginning, I would have spent the entire podcast coming up with lyrics, and I probably have something by now.
Driving my truck on a rainy night. The road ahead looked wet and wide.
I put up a barricade, but I thought I got myself an F-150. I don't know.
Well, it's a Nissan, I think. Nissan
Whatever.
Frontier. Yeah. Okay. So this is
No
uh,
barricades a frontier for me. I got myself a Nissan.
a
Four-wheel.
pickup truck driver. Literally got out of his truck, moved a road closed sign out of the way. That can't be there for any good reason, right?
Why should it be close to him? He's got a truck.
Yeah. And he then drove into a construction zone, directly into basically up to the top of his wheel wells, wet concrete, where I'm assuming he got stuck at that point.
Yeah. Yeah. He wasn't going any further.
Yeah. So
There is
yeah.
a lesson there.
Gosh. A lesson people really shouldn't have to need to be taught to them.
That should be part of driving education, I think. Don't move a barricade that says "Do not enter."
Yeah.
Drive around in the hopes that there won't be fresh concrete.
Yeah, it should be obvious, but apparently it's not.
Expensive mistake. I have to assume that alcohol was a factor, but it seems like one of those decisions that I don't know. As I was looking for ridiculous drivers this week, there was a lot of really stupid driving, like really bad driving, people driving at speeds that were just like off the charts.
Ask me why it took me so long to get from court to where I was when I did my hearing. Ask me why.
Accident,
No, stupid driving.
stupid driving.
Driving stupid.
Yeah. What's a
Said that
stupid
to
driving out there?
my 12 o'clock adjudicator when I was like, I just walked in the door 2 minutes ago. So
Yeah.
you should know that we're gonna have job security forever.
Yeah.
Because nobody knows how to drive.
I don't know. Seems to be much worse. I know, like a few years back, you remember David Eby wanted to try and encourage people to learn the rules of the road, and then they just didn't do anything about it. Like it was his topic of the week. He must have been pissed off, and then they did nothing about it. No further education. No, nothing. There's so little public education about driving and driving rules, and it got a lot worse like post-pandemic, huh?
Excuse me, I am a one-woman public education on driving rules.
I'm talking about government doing
Yeah.
their job to educate the public. You are the one person who's out there doing. I do a little bit, but I'm nothing compared to you. I mean, you're so prolific. Oh my gosh.
I was in traffic court today and was saying hi to the officer, and not an officer I'd met before, and he was like, watch all your TikTok videos. I just
Mm,
love them.
yeah. Well, they're good. You are you are the source of public education in this province. Everybody else has dropped the ball. Government's dropped the ball. There's no other lawyers doing it like you. There's nobody. In fact, not in BC, just in BC. Across the country, there's nobody who's doing it the same way you are. There's a few lawyers out there with their TikToks, but they are some are very good and very informative. Some are very self-promotional or promotional. Yeah, I just think that your material is better just because you're focused on, eyes on the prize. You're there to explain the issues. So
I'm
good
trying.
work, Kyla Lee.
Thanks. Speaking
Yeah,
of work, I gotta get back to it.
back to it. Yeah, I got to pack up and get out of here. The mosquitoes have won. I lost. Okay, take care.
Hi.
Oh,
Oh, that's our podcast. Yeah. If you have a driving law related issue, you can find us online at vancouvercriminallaw.com or give us a call at 604-685-8889 and tune in next week for another exciting episode of Driving Law.